county in which he successfully completed the promotion.
All right, thank you very much. State.
Your Honor, the state is requesting that the bond remain the same at this time. Your Honor, the facts and here the allegations include that the defendant had shot the victim in the chest. He suffered a gunshot wound to the chest. He suffered a loss of his spleen and a portion of his liver was removed. The defendant also fled the scene of the vehicle, Your Honor. I will note, Your Honor, I have been having a little bit of trouble with the phone numbers. I have the detective is working in on that. The detective has no reason to believe that he isn't willing to participate in the prosecution of this case. So with that, Your Honor, the state is asking that the bond remain the same due to the seriousness of the offense, using a firearm and shooting somebody in the chest.
The complaint states that the allegations and charges stem from an investigation based on video surveillance, victim statements, and officer investigation. And the allegations are that he shot someone in the chest.
Yes, Your Honor.
Well, the considerations for bond include risk of flight, danger to the community, and public safety. And given the allegations involving shooting someone in the chest with a gun, the bond being 100,000 straight, and juris monitor if requested. I think that is reasonable given the circumstances and considerations that the court has to consider. And so the motion to reduce the bond is denied. The bond will remain the same, and we will be back here on December 11th at 9:30. Anything else?
No, Your Honor, thank you.
State?
Nothing.
Who do we have next?
Mr. Blackwell.
Or is there anything we can call? Ms. DiVincenzo, are you ready?
Yep.
Yes, Your Honor, I called, we had the court's ready to be down
Yep.
there. He's in lockup, but I believe he's appearance.
All right, this is the matter of State of Ohio versus Donald Ray Ayers, case number B2505-392. Ms. Courtney DiVincenzo is present on behalf of Mr. Ayers, and Ms. Kay Hennigan for the State of Ohio. This matter is set for a pretrial today. Ms. DiVincenzo, we have a final pretrial conference date set January 15th, a jury trial date set January 26th. Do you have discovery yet?
Yes, Your Honor, I have, discovery from the prosecutor, and she just handed me, the informal paper discovery now. One thing I did want to address with the court is the jury trial date. I have another trial scheduled that day, and didn't know if it was possible to move the January 26th date. I just want to bring it to the court's attention now.
All right, well, a couple of things before I consider moving it. Number one, is it in common pleas court or municipal court?
Competition, Your Honor.
Okay. And the other case is your client in lockup or out?
She's out.
She's out? Okay, then I'm not moving it. Your client in this case is locked up. He's gonna take precedent. All right. So anything you want to put on the record with regard to discovery?
Your Honor, I just note that I did get, over the paper today, and BWC and here, photographs were sent, so I believe that's complete at this point.
All right. So let's go ahead and set a date in December just to keep the case on track. And so in case there are any pretrial motions you want to file, Ms. DiVincenzo, or you want to address any pretrial motion, we can have a date for it. So let's go ahead and continue this for another 30 days. Or 3 weeks, 30 days.
Are you available Wednesday, December the 10th?
About Wednesday, December 10th. Does that work for you?
Yes.
Okay. Wednesday, December 10th at 9 a.m. This time, wait until the trial date.
Yes, ma'am.
All right, and have you had good communications with your client?
He's, locked up.
Yeah,
Yeah, sorry, I spoke with him this
no. I'm still
morning.
checking.
Sorry, I spoke with him this morning and let him know that I
Okay, thank you. All right, thank you very much. Ms. DiVincenzo has 2 cases.
Yes, I just want to talk to Ms. Hennigan real quick about Mr. Garland's program.
Okay.
I think we can do yard over there, if that's okay.
Okay. This is the matter of State of Ohio versus Antonio Yarbrough. Case number B2504-820. Mr. Yarbrough is present in the courtroom with his attorney, Mr. Clyde Bennett, Ms. Kay Hennigan for the State of Ohio. Mr. Bennett, we have a trial date of February 9th.
Correct.
And a final pretrial conference date set January 29th. Do you have discovery on behalf of Mr. Yarbrough yet?
I just received.
Okay,
This morning.
all right, thank you. And Ms. Hennigan, would you like to put anything on the record with regard to whether or not it's complete?
Sure, Your Honor, I do anticipate there being body worn camera in this case, and I do not have that.
All right, so we still have body worn camera evidence outstanding. All right, so, given the trial date is not till February, I'd like to put another status on, next month, to make sure discovery gets completed, and, in case there are any pretrial motions you want to file, Mr. Bennett. So,
Thursday, December 11th.
Thursday, December 11th, can you?
Not available, I'm available, that's all.
All right, Wednesday, December 10th at 9 a.m. This is a trial date, this time wait until the trial date of February 9th.
Yes, Your Honor.
All right, and, is Mr. Yarbrough keeping in good contact with you?
Yes, he is, Your Honor.
All right, excellent, and staying away from the victim, alleged victim?
No contact with you.
All right, excellent. Any, you want to put on the record?
Nothing else.
Mr. Bennett, anything else you want to put on the record?
Nothing.
Okay, thank you very much. Ms. Arlen, is your client outside?
He is, yes, Your Honor.
Okay, I just got, one person coming down, that's Ms. Glazer, Ms. Stephen Chenzo, and I'll call you.
Thanks very much.
Uh-huh. What happened to Ms. Mallory? She left.
Should be back. Her client.
Mr. Ranger, do you have something that can call?
Your Honor, I'm on the case with Ms. Mallory.
Oh, gotcha, okay. She's on her, you can back.
Did you think you already had Gregory Martin?
This is a matter of State of Ohio versus Gregory Barber, case number B2505216. Ms. Stephen Chenzo is present on behalf of Mr. Barber, and Ms. Paige Hennigan for the State of Ohio. Mr. Barber is in the Justice Center. Do you want him to be brought down?
No, Your Honor, please, yes.
Okay. We do have a final pretrial conference, date set next month, December 18th, and we have a jury trial date set January 12th. Do you have discovery yet?
I have some discovery, Your Honor. I just spoke with Ms. Hennigan. A couple things are outstanding. Body worn camera. Sounds like a regular surveillance video, potential phone dump, and maybe some like detective interviews type situation. I know Ms. Hennigan's making efforts to get those items to me. That's the status of discovery.
All right, Ms. Hennigan.
That's correct, Your Honor. I am waiting on all of that. I've done multiple requests at this point, so I'm waiting on that. Additionally, I'm waiting on ballistics from the lab. They said that they just sent it to the lab on Wednesday, or, yeah, Wednesday.
All right, well, Mr. Barber's been in custody for 53 days without any discovery. If you need to subpoena the officers for the next date, I am in total agreement with that. Our final pretrial conference is December 18th, but I don't want to wait until then. So let's get another date before then, Ms. Howard, where we can squeeze it in.
As long as we can do it during the meeting, Tuesday, December 2nd.
Tuesday, December 2nd?
I am not available that day.
Okay.
I do December 3rd. I'm available 3rd, 4th.
Yeah, 3rd, 4th, and 5th, the county judges will be out. Will be in Columbus.
Okay, could I do December 1st?
No.
Could I,
Second. Yeah,
could I come back, the following on the 10th, December 10th? Is there any here for Mr. Ayers?
yes.
Yeah, we have a final pretrial conference on the 18th, so,
I'm happy to come back with the, give me that,
no.
okay.
All right, I guess we'll be back on December 10th. Is that a Wednesday?
Yes, ma'am.
At 9 a.m. time wait until the trial date of January 12th?
Yes, ma'am, I did also want to address the trial date with the judge.
Okay, so, December 10th, I'm expecting discovery to be completed since we have a final pretrial conference 8 days later. So state if you need to subpoena the officer, please do so. Just want to make sure that gets done. What would you like to say about the trial date?
Your Honor, I have another trial that's scheduled for that day. That gentleman is locked up in his common police case. I set that case quite some time ago for the January date. I would request a continuance of the January 12th date, sort of the court not have time, if that did not work for me.
Yeah, is the other case over here, client's been locked up longer than this one?
Yes, ma'am.
Well, are you willing to waive that time? Well, I'm happy to do that. I'm glad you gave me a heads up. The next date, I'm gonna bring your client down and he can waive time on the record,
That's fine.
okay? And then I'll put a note in here that you're gonna wanna move that date. All right, thank you. Anything else?
No, Your Honor, thank you.
Thank you. Steve?
Your Honor, I will just, I guess I will note, I'm looking at, so we have a co-defendant that was arrested and indicted about a month later. I believe that's a Judge Johnson. I am looking into consolidating those, but I believe we have.
Wait, you said,
Sorry, but, he doesn't.
I hear slow.
He does have a co-defendant. He was arrested and indicted about a month later than Mr. Barber. That is in Judge John's room right now. I am looking to consolidate that. I will file the appropriate motion, but I do believe we have a lowercase number for that.
I have lowercase number. Okay, that's fine. Yeah, we'll put them together. Okay.
Thank you.
And that will automatically move the trial date.
Thank you, Judge.
All right, thank you. All right, is this Mr. Blackwell?
It is, Your Honor.
All right. This is the matter of State of Ohio versus William Blackwell, case number B2505316. Mr. Blackwell is present in the courtroom with his attorney, Ms. Angela Glaser, and Ms. Paige Hennigan for the State of Ohio. This matter is on today for a pretrial. Ms. Glaser, we have a trial date set January 26th and a final pretrial conference date set January 15th. Do you have discovery from Mr. Blackwell? Okay, Ms. Hennigan?
Your Honor, I do have paper I can get for today that I forgot about, but I did send an fax on Monday, which included photographs, NVR, BWC, 911, cell phone radios, and drone footage.
All right, so we gotta get the discovery in. So let's set this for sometime next month to make sure that we get the discovery. So let's continue for pretrial.
Can you do it in December 10th, this last?
Yeah, not on the 10th, and try to make this a good Yeah.
We only had 2, we set like 3, so we had 5.
Okay,
I'm available on this.
all right, December 10th, 9 a.m. Is time waiting until the trial date of January 26th?
Yes, Your
Okay, so I know there's a pending motion to reduce bond. Ms. Hennigan, did you receive a copy of the defendant's motion to reduce bond? And have you had an opportunity to comply with Marcy's law?
Your Honor, I've made multiple phone calls, we didn't have a good number, so yes.
Okay, all right, who'd you like to say?
Judge, thank you. As far as aware, Mr. Blackwell's bond was initially set at $200,000 secured with EMD when he was arrested. Judge, we're asking the court to consider a $20,000 bond with EMD if the court finds that it's necessary. He would even comply with the GPS monitoring attachment if the court finds that's necessary as well. In mitigation, Judge, he's 21 years old. He was employed part-time at Garden Park Nursing Home for 3 years. He works in
Garden Park, where's that?
in Avondale.
Uh-huh.
And he's worked in the kitchen there, and that was verified by pretrial services. I even asked him a number of details about the facility and what he does there, and he was able to give me as many details as when the truck deliveries come from the kitchen. So I am convinced that he has been working there for that length of time. He has strong family support, Judge. I can tell you, he has a number of family members here in the courtroom, one of them being his grandmother, one of your peers. She was so concerned when he was arrested that she drove up from Alabama. She does have a home here, but she's been residing recently in Alabama to be with family there. He also has no contacts at all. He has no juvenile contacts. He has no contacts as an adult. He was given a risk assessment score of 2, and the only reason why he received 2 points is 1 for his age, time of arrest, and 2 because he only worked part-time rather than full-time. Otherwise, he would have a risk assessment score of 1 just based on the age at the time of the arrest. Judge, what I know about the case so far, and talking to his prior counsel as well, we believe the allegations here are exaggerated. I don't typically go into the facts of the case, but Mr. Blackwell was cooperative with police and gave a statement to them, essentially telling you what I'll tell you now. But he invited some female friends over to his house when his parents were there, and the next day it was discovered that his stepfather's firearm had been removed from the home. He reached out and tried to get the firearm back for his stepfather. He was told that he needed to provide a finder's fee. That's how this all ensued. He was told to show up at a location. I believe he was set up. He's from Warren, Ohio, which is a small county, much smaller than Hamilton County. But this is kind of typical of what I've seen in these types of allegations. But what I'll tell you, Judge, is I don't think he's a flight risk, and based on the contacts I've had with the family, I'm convinced he will have no problem appearing in court. But the family is of modest means, and so I think to ensure the safety of the community, you could attach an EMD. They could try to reach out to the alleged victims in the case and see if they want a GPS. I don't think they'll respond, but if they do, he's fine with that. But he could do the EMD at his mother's address or his grandmother's home here. They both provided addresses for him, which we're happy to give to the court.
State.
Your Honor, the state is asking that the bond remain the same at this time. The allegations here include that he pushed through this residence with 2 of the victims being present. They were 18 and 16. He had a firearm in his hand. One of those victims was recording, and he did have that firearm in the video. You can see him waving it around. Additionally, Your Honor, there was a 2-year-old baby in that house when all of this was occurring. So for the safety of the community, asking for the bond to remain the same.
So the allegations in this case is that this young man went to a location and was armed with a firearm and busted his way in the apartment or wherever it was, waving the firearm.
Yes.
That's the allegation.
We obviously dispute the allegations, Judge.
Okay, I understand. I'm looking at I'm looking at a complaint that says that it's not only based on the victim's statements, but they have a video. So we can't dispute video. Everybody has video nowadays. This is pretty serious. Again, I'm going to say on the record for this case that, the considerations for bond, which most people don't know, is risk of flight, danger to the community, and public safety. And when you have allegations, because I don't know this young man, I take what the defense lawyer says, that this is a bad situation. He has a lot of family support. But the court has to look at danger to the community. And I hear allegations of someone busting into a place with a gun. The allegations are that he pointed the gun and threatened to shoot somebody, and there's a video. It's kind of hard to get balance that with community safety. So, The bond is 200,000 straight. All right, so, bonds are set in Room A. Room A has a rotation of judges. I just reviewed a bond for someone who shot someone in the chest, and that bond was 100,000 straight. That came out of Room A. And then this one is allegations of a young man pointing the gun, threatening to shoot somebody, and it's 200,000 straight. This is why the public thinks that the system is not fair, because they see different allegations. But it's only because we have to make a decision based on the facts before us, and different people see things differently. Given the fact that I just allowed a bond for someone actually shot somebody to remain the same at 100,000, I will reduce this bond to $100,000 straight. All right,
All right, thank you, Your Honor.
thank you. Yeah, plus E and D.
Just don't be on that page.
One thing you could do your response. You could be responsible. No, that's it. That's it. That's it. Stay away from here. Exempts.
Judge report call on roll call.
Just sit here, just get behind. This is a matter of State of Ohio versus Merrill K. Arnold, case number B2404637. Mr. Arnold is present in the courtroom with his attorney, Ms. Arway, Ms. Lindsay Arway, and Mr. Brandon Brown for the State of Ohio. This matter is on today for sentencing. Mr. Arnold, having entered a guilty plea on October 14, 2025, to count 1, gross sexual imposition, a felony of the 3rd degree, as charged. Count 2 was dismissed. The court ordered a pre-sentence investigation report, a victim impact statement, a River City evaluation, as well as a advisability of treatment assessment. Counsel, have you received a copy of all of that?
Yes, Your Honor.
All right. State?
Yes, Judge.
All right, thank you very much. For the record, I will indicate that I received a letter from River City Correctional Center dated October 22nd, saying that Mr. Arnold is an appropriate candidate for the River City program. And so I have that. I also have 2 letters from the victims in this case. Have you had a chance to see that?
Yes, Judge.
Okay. And then I also have a report dated November 10th, 2025, from the Southern Ohio Forensic Evaluation Services that is authored by Dr. Laura Davis, forensic psychologist, and have you had a chance to see that?
Yes, Judge.
Yes, Your Honor.
All right, thank you very much. Are we ready to proceed with sentencing?
We are, Judge.
Ms. Arway, what do you want to say on behalf of Mr. Arnold?
Thank you very much, Your Honor. Mr. Arnold obtained our services in September of 2024. At the time that these allegations were reported to law enforcement, he has since then maintained contact with our office. We appreciate the state allowing us to arrange for a turn into room 585 on these charges. Mr. Arnold has expressed sincere remorse since the day that he and I very first spoke. He has, I believe, taken this very seriously. He's engaged in counseling services on his own, not required from the court to address certain conditions. To the best of my knowledge, Your Honor, there have not been any prior allegations. Mr. Arnold has no prior record other than his convictions here in this case, and I believe for traffic infractions, a red light ticket. Otherwise, he has lived a law-abiding life. We understand the nature of the charges that have brought him before the court are certainly very serious, but he again has taken the charges with the seriousness that they deserve, and again has enrolled in the treatment. I know again he's expressed sincere remorse to me, to both of the victims in the case. I know that he also has a letter that he would like to read to the court. I'll give him the opportunity to do that here very shortly. It is my understanding, Your Honor, that as Your Honor has noted, he does qualify with the appropriate candidate for River City. We understand that there is a presumption of prison in this case, but we are asking Your Honor
to consider allowing Mr. Arnold the opportunity to get treatment through River City. I think that that would be appropriate in light of the fact that he does not have any prior allegations or convictions of such nature, that he has taken this very serious himself, as self-enrolled in counseling, has been prepared to accept responsibility for the charges since retaining our services over a year ago. And I will turn things over to Mr. Arnold now to read this letter.
Thank you, Your Honor. I'm sitting here not to defend my actions, rather to say that I am no longer the person I was 10 years ago. These last 10 years, I have realized the direction my life was taking and the effects it was having on those who count on me to love them and be there for them. I have dedicated my life to God, and I am fully committed and dedicated to who God wants me to be and what God has in store for me. I have undergone self-reflection and have been seeing therapists for a little over a year now in a Christian-based 12-step program called Celebrate Recovery since August of 24, where I have learned to bring the things I am struggling with to God and the peers around me. That has allowed me to see the things buried deep inside that I had blocked, that had blocked my potential to be who I am supposed to be. I have since been able to make it a priority to help other men by becoming a mentor to those who have struggles are similar to mine, so that they can help them not make the same mistakes that I have made. I am deeply sorry for the people I have hurt through my actions. I can promise that these issues have not resurfaced over the last 10 years and will no longer be an issue. I will and am continuing to seek professional help. I am not a threat to society or to anyone any longer. I have had a great deal of loss over my actions. However, through all this, I have been able to keep my eyes fixed on God and His purpose for me. No matter the outcome, I will continue to grow. I will continue to allow God to work through me for His glory. I wish I could take back those things. However, all I can do is move forward, be the best person I can be, and not allow what I did in my past and my current situation to dictate the type of person I will become. Thank you, Your Honor.
All right, thank you very much. Steve?
Judge, I've had the opportunity to review everything in this case, and I've spoken with both the two victims and the father of the victims as well. Looking at the officer's statement, Officer Stockfire, I believe that he makes the point that he would leave it up to the victims in this case, Sydney and Madison. They are of two different minds on what they want to have happen in this case. He indicated, and I would also indicate as well, is that a description of what Sydney has said, while it still only qualifies gross sexual imposition as a felony third degree, it is more severe than things that Madison said. I know both want to be able to address the court today. Sydney would like to read her statement aloud, which was previously submitted to the court. Madison also wants to speak, although she didn't have a prepared written statement that was submitted beforehand. Judge, this is a difficult case. Obviously, the actions of Mr. Arnold, the consequences of those actions stem beyond what happened 10 years ago with his daughters. Sydney talks about difficulties she's continued to have. Obviously, Madison now has 2 kids, and she was concerned about them, which is what led her to confront Mr. Arnold. And even in Mr. Arnold's own evaluation, he indicated things that happened earlier in his life, witnessing sexual assault of his sister, and also some instances that happened with him, that this kind of behavior begets a cycle that is difficult to stop. No matter what the court chooses today, I think that mandatory treatment is necessary and must occur. As far as incarceration goes, I would also defer to Sydney and Madison. They are the 2 individuals who have been affected the most by this, and I think that their wishes should weigh the most in terms of what the court decides to do.
All right, thank you very much. David likes to step up. Mr. Arnold, if you wouldn't mind stepping to the side of your lawyer.
Judge, Mr. Bailey also would like to read his statement aloud as well.
All right, thank you.
My name is Sydney Bailey. Marvel Arnold, you killed me that day. The day before creaking stairs would be the most gut-wrenching side for me.
Can you put the microphone down? We can start to hear that. Okay, go ahead.
The day before heavy breathing would no longer be a creepy monster hiding in the dark. The day before my entire life would be ruined by somebody else. But with all the irony, that's not what hurt me the most. His actions ruined me. They ruined the way I would perceive sex and romance for the rest of my life. They ruined they ruined my understanding of safety, ruined my every waking thought, but most of all, ruined a sister's relationship, and ruined a mother and daughter relationship. You ruined a family. You told me not to be angry with my mother, but then again, you would tell me as an apology that that your actions came from a long line of this behavior. How could I not be upset with her? My savior. My mother was my rock, the one who I would tell everything. The woman who had known me 9 months before the world got the chance to. I fessed to her the next day that something wasn't right. I was 6 years old, and I asked him if all these things you were brave enough to do throughout the day were things that married people would do. Just because I didn't understand. Everything was a bit of confusion. I wondered if somebody had broken in, if I had dreamt it. I hoped and prayed that it wasn't you. I hoped that somebody had broken in so that it wasn't a man I was living with. But by then, I knew your figure well enough to know the ankle popping, heaving coming from the basement wasn't just a monster hiding down there anymore. You are a monster married to my mother, and it would tear us apart from the inside out. It always made me wonder if you planned this from the start. Did you come into our lives knowing we'd start chaos and ruin what little we had? I told my mother that night when she took me in. She used to fake the concern and stress, but after a simple "did you do it?" that's all she needed to hear. And then I was left all alone, to my own devices, and all while my older siblings were screaming at about how my father was so evil and putting things in my head. And today he's the only parent that's standing beside me. When investigators asked for a timeline, I could feel my throat swell and sweat washes over me. The only answer I can give nowadays is duration, and it kills me. It kills me that I can't be more helpful to investigators, the prosecutor, the judge, and most importantly myself. As I grew up, all I could think about was not that only had I come forward, which is a rarity in itself, but I was denied any form of support or action. The biggest pain of it all was the look I got from my mother that told me she'd cut all sympathy I'd been given as a child, and she didn't believe me again. After 10 years of mustering up my courage, I was tossed aside again. And when I pleaded with her to ask him herself, you dug that nail into my coffin. You told my mother that you did it a little bit. Years of tears and sorrow, and that's what it was boiled down to. But I stand here today for me. What Merle did to me wasn't not enough to deserve punishment. What you did to me was far beyond what anything should have to experience, beyond what any child should have to endure, and I believe that you deserve everything coming to you. Thank you.
Thank you.
My name is Madison Wiegand. I am the other victim of the case.
Okay, I need you to speak up just a little bit. I can't hear.
Sorry, my name is Madison Wiegand. I'm the other victim of the case.
Thank you.
So I don't have a prepared statement, but I do want to attest for the character that Penny is, because despite being one of the victims, I still had Penny in my life. I confronted him myself prior to my marriage, because I wanted everything settled. Everybody was fighting with walking down the aisle, and I wanted both my dads there because they both played a significant part in my life. I wasn't concerned for my kids until I future had them, but I believe Penny has taken steps to prevent a reoccurrence. He's gone through some therapy, he's apologized profusely, he follows the regulations set in place. both by my standards and everybody else's. I believe that sending him to sentencing to prison time will do him any good.
Can you tell me how this affected you? How what he did affected you?
It was damaging at first. I got labeled as a liar when I confronted my mother. For a very long time, I kind of went a very, stage and everybody going on, just everything going on. I was kind of the black sheep for a minute. But it really hasn't impacted me. I mean, I moved on, I got married, I got my college, I had my kids. It has not had such significant impact to where I feel like it's super.
When did you become a victim? How old were you?
I was about 13.
Your sister was 6 or 7.
Correct, she's significantly younger.
At the time, did you know that he was victimizing her?
No, we actually found out a couple years later. We were hanging out together and I had confronted her about it and asked her if something similar had occurred to her, and that's when we kind of talked and realized that we had both gone through something very similar. And then since then,
How did you feel about that?
I was upset because it's easier being the older sibling, being able to take that burden on yourself, but feeling that and affected your other siblings is hard. I spent a lot of time being my siblings' foundation and not being able to protect them from something I knew about was difficult.
And how's your relationship with your sister?
We don't talk anymore. We're not on speaking or visiting terms.
Why?
I disagree with how the things came about. The whole situation that led to this big debacle, I disagreed with, and she didn't like my position on things, so she didn't want to speak anymore.
So my question to you was, how has this impacted your life? And you said it didn't. But actually,
It
what
has.
I hear,
I disagree that he is the focal center of it.
well, what I hear is growing up, you were your sister's, you thought of yourself as your sister's protector.
Mhm.
And when you learned about what your stepdad did to her, you said it was damaging to you at first, but when you learned about what it did to her, you were very upset. Now, as a result, you and your sister, is that your blood sister?
Yes.
You and your sister don't even speak. Do you feel a hole in your life in some way? Any way?
I am a person that's not going to seek people who don't want me.
That's not going to,
Seek people who don't want me. If my sister doesn't want to speak to me, that's fine. I have 2 wonderful kids. I've got a husband. I've got other people that are going on. I had told my sister during this whole fallout that I did not disagree with what she did, but disagreed with how and why.
do you love your sister?
I did,
Have you always loved your sister?
of course.
It doesn't bother you that someone you love, that's your sister, that you don't even speak to because of all of this? Does it bother you?
I love my stepdad and I love my sister. It's a very hard position to be in. Yes, the actions he did were wrong, but I also believe that other people's reactions and actions after finding out were also wrong.
Would you feel the same way if this were your children?
No. I would be a lot more livid because they were my own kids.
Okay, thank you. Your name, sir?
My name is Justin Baker.
Thank you. And are you both girls' father,
Yes, ma'am.
biological father?
Yes, ma'am.
Thank you. Would you like to say?
As I said, my name is Justin Bailey. I'm the father of Sydney and Madison Bailey. Over the course of the past few years, I've watched my daughters change, some for the best, some for the worst. I've seen them go through the most extremes of depression, hatred, guilt, frustration, mood swings, and loneliness that I've ever encountered. I've seen my daughters close off the world, Sydney so much so that she had to be medicated. I've seen my whole world ripped to shreds and don't know how or why. Just recently, my daughters felt it was time that I had to know what they were going through. They gave me a snapshot of what was going on and what went on without going into extreme detail. I still to this day do not know exactly what took place to change both my daughters in such a drastic fashion. But with the investigations, phone calls, court hearings, charges, and plea deals, I can piece things together for myself to understand more. Madison became an adult, wanted to move on with her life, forget everything that ever happened, and not live in her past. She got married and started her own family. While Sydney took more of a blunt for a longer period of time. After my daughters informed me of some of the things that their stepfather had done to them, I went through a whole mix of emotions. Emotions I haven't felt in a really long time. Emotions I haven't felt since serving in Afghanistan or Iraq. You destroyed my daughters. You took their innocence away from them. You took their sense of safety away from them. You took their sense of trust away from them. I, as a soldier, always used to tell my kids before deployment that Daddy was going to go fight the monsters like Harry Potter does, so this way they would always be safe. I never thought the monster wasn't 1,000 miles away from them, but living under the same roof as they were. You were entrusted in keeping them safe while under your care, while I was keeping them safe on the seas. You failed your mission. You preyed upon little innocent girls that looked for you for protection while their father, me, was away. Sydney had been medicated, has to go to counseling, has nightmares where she doesn't sleep, was self-harming and self-mutilating, and trusted no one due to your actions. Since Sydney has moved in with me to another state almost 100 miles away, it has taken a little over a year for her to have some sort of normalcy in her life. She finally knows that she is in a place that she is loved, she's respected, and she is above all else safe. She still continues to go to therapy and deal with the trauma that you have caused her. As her father, there is no punishment that is good enough for you that will be sufficient to me. But knowing for the rest of your days you will never be able to hide the fact you've done these monstrosities from the world, that is where we'll have to start. There's a special place for people like you, and living in freedom is not.
Thank you, sir. Thank you for your service. All right, anything else? from the
Nothing else
state?
from the state, Judge.
All right, thank you. All right, Mr. Arnold, I'd like to hear from you now, if you have something you'd like to say. If not, that's okay too.
Just want to, just apologize to those people who love me and trusted me, with mistakes I made. And I will have to live with that for the rest of my life. And I know apology doesn't make it better. That's all I have.
You married your mother?
Yes, Your Honor. We are in the middle of a dissolution, however.
Is she here today?
She is not.
From my review of the precinct's investigation report, as well as the victim's statements, what I've heard here today, you married Sydney and Madison's mom, and within a year, of coming into the home the abuse started. They were 6 and 7, 6 or 7, and 13 years old. And you abused both of them. When I listened to the victims, as you heard them, the things that echoed so loudly were, his actions ruined me. You were a monster. It was damaging. And what is most tragic as a result of your actions, as horrific as they are, is that there is now a wedge between two sisters who were both victims of your actions. See, that's the thing about when we set something in motion, any of us. We don't get to control the consequences of it. We don't get to control the reaction to it or the response to it. Once we make an intention, set our intention to do a thing. The damage that you've caused to these girls, despite Madison's words that she's moved on, were really catastrophic in the lives of these now 2 young women. And I hope that in some way that you will continue to get the help that you need, as well as they get the help they need to move past this. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact, not only on Sydney and Madison and Mr. Justin Bailey, but also on society, and to be consistent with sentences and commensurate with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Mr. Merrill, I hereby sentence you to a term of 36 months in the Ohio Department of Corrections with credit for 0 time days served. Upon your release from prison, you shall be on post-release control for 5 years. Costs and fines will be remitted. I don't know if there's any restitution.
No objection.
No restitution requested. It's my understanding the parties have agreed that Mr. Merrill is a tier 2 sex offender.
That's correct.
All right. I I am going to explain your duties to register as a sex offender now. You have been convicted of or pled guilty to a sexually oriented offense and/or child victim offense as defined in Revised Code 2950.01, and you are a Tier 2 sex offender registrant. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state, but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment, if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state, but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you've been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. You are required to provide to the sheriff temporary lodging information, including address and length of stay, if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and/or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered, and to the sheriff in the county in which you intend to reside or establish a place of employment and/or place of education, at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address. You must register with the sheriff at that fixed address. You are further advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to criminal prosecution. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to you or used by you to the sheriff with whom you have most recently registered. Because you are a Tier 2 sex offender registrant, you are to comply with all of these requirements for a period of 25 years with in-person verification every 180 days. Since your expected residence address, as stated above, is located in Butler County, you shall register in person no later than 3 days after your release from prison with that county sheriff's office located at 442, this is South 2nd Street, Hamilton, Ohio, 45011. Failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in residence address or other required information as described above will result in criminal prosecution. There's a place here that is for your acknowledgement that the above requirements have been explained to you and that you understand that you must abide by all provisions of the Ohio Revised Code, Chapter 2950. Mr. Merrill, Arnold, is this your signature right here?
It is.
All right. And I'm going to sign it and give you a copy before you leave the courtroom. Is there anything else from the state of Ohio?
Nothing from the state, Judge.
Is there anything else from Ms. Arway?
No, Your Honor, thank you.
All right, you have a right to appeal your conviction and your sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? All right, I'm gonna, fill this out. All right, we are adjourned.
Thank you, Judge.
Thank you.
Where is, Sydney? Can you still here for a moment? Can you come with the, you can come with your dad and get an advocate? All right, who do we have next? Is this, this? Joseph. This is the matter of State of Ohio versus Robin Chester, case number B 2404989. Mr. Chester is present in the courtroom with his attorney, Ms. Anna Mallory, and I thought Mr. Winter was doing this case.
Your Honor, he had a leave to, he was starting a trial, so I'm stepping in for him.
Yeah, no worries, okay. And so Ms. Paige, Hennigan is present on behalf of the State of Ohio. Ms. Victoria Todd is present for probation, and who else do we have here? Go ahead. Last name?
Maureen Timon.
How do you spell your last name?
TIMON.
Thank you very much. All right, so this is a motion to mitigate. Ms. Mallory, what do you want to say?
Your Honor, the reason I called the motion is because, and I can't remember if I put it in the motion or not. Judge Berkowitz sentenced Mr. Chester to 6 months in the Justice Center. No 2-for-1, no 3-for-1. Mr. Chester's municipal court attorney filed a motion to mitigate the sentence, explaining to Judge Berkowitz that you had sentenced him to River City.
So you get treatment.
He denied it. So he cannot be in River City until the 6 months in the Justice Center is complete. And I don't want to get into the mind of the court, but my impression from the court was not that the court wanted him to be incarcerated for a year.
I did not.
So that is why we're coming before you to see what the court would like to do, if the court would want to mitigate his sentence. He's just sitting in jail.
With no treatment.
No.
All right. Well, I don't know what his municipal court case, what he was convicted of there.
I think it's a
Oh, yes.
I think it's
I see. Okay. Well, when is he scheduled to be done with his sentence from the municipal court?
I'm looking at Prairie Johnson, it looks like she has that answer.
119 is 180 days.
January 19th?
January 19th, yes, and that was, because I've been in contact with EPA, and he also has the EPA hold. He plans on listing that after he completes the 6 months, so he can move into River City, because I guess my understanding, EPA, he had a violation, and they were gonna back it off to his felony, and just go River City instead of sending him to prison to get treatment. But, so as of right now, that is what the game plan is. River City is expecting him on that date. I know I tried to see ways around it, but with the way that the judge wrote it, there's nothing I personally can do to make it move any faster.
I see. All right, so what are you asking me to do then, Miss Mallory?
I don't really know what the answer is. Is it possible for him to get treatment in jail? Absent?
Yeah.
It sounds like he can't even get treatment at the jail now, with Judge Berkowitz not being so.
When is Judge Berkowitz's last day?
Not until January, so it would be like 2 weeks before.
Oh, I see. Okay. Well, so if you're asking me to mitigate his sentence, are you asking me not to allow him to go to River City?
I guess it sounds like it'd be better for him just to go to prison now, because if he went to prison now, then it would be, Judge Berkowitz's sentence would be required to run with prison. But as a matter of law, that sentence would go with the felony sentence.
So
it almost sounds like it's better for him just to go to prison.
But he has a parole holder, so they're gonna do something after even my sentence, which is send him to River City.
Well, I don't know if they would send
It
me
could be
to
River City or prison. Like, if you send him to prison, I'm sure from a conversation with his agency, they'd be okay with that as well. But we were hoping that he would get some sort of inpatient treatment for
Yeah.
his drug use.
My experience with parole is that if you go to prison, then they don't last at you. They don't do a sanction.
Oh, I see.
Prison.
I
So-
see. Wow, this is.
I'm trying to help you out, and you're stuck until January, period. So it seems like it would almost be better to just give him.
What do you want, Mr. Chester? Do you want treatment? That was my goal for you.
I would like treatment, like, would I have to really be incarcerated for a whole year? I mean, is there any way that I can do like a lesser program after 6 months is completed? Or maybe an outpatient class, because I mean, I've been sober for 4 months. You know, I have my mind clear. You know, I really don't want to do drugs anymore. I only violated my probation one time, and it wasn't for it during the time.
Yeah.
You know, and I'm getting scared for them for the whole year for a 6, they only in the 30 year. You know, I would like to be released, talking about your release in January 16th, January 19th, I can go to an outpatient program, you know, of my life. Or even an inpatient for 30 days.
Well, I guess let me ask the state, what would you like to see?
Your Honor, I'll also like to defer to the reply brief that Mr. Rendering did, that indicates that, complete River City, once that becomes available.
Yeah, okay. So I did add a year to his community control. So that doesn't even start till he gets out, right? So what I can do is I can grant the motion to mitigate and, terminate the requirement of River City and change it to outpatient. Unless that's going to be contrary to what parole is going to do.
I think parole from the Central Prison, to be honest, in conversation, if he didn't get to River City,
I see.
we were trying to work together on that. My only thing with outpatient is he did complete 2 rounds of Crossroads, but both times he got out of Crossroads, he either went missing and didn't give me an address, or AP reported he was picked up, and I think I put in my report one time, AP picked him up over there by Kentucky State, so it was on me. So he was dirty, sat in jail, I didn't violate him off of it, because he went back to Crossroads. So he was using like his app, he was out, I just couldn't get him in the office because he wasn't coming to see me, so I was relying on other factors.
Well, how about we, do the motion mitigate and do 60 days of River City upon his release from municipal court, sentence in January. Then he'll do 60 days at River City.
So you're not so much.
So like it's on my shift.
That hopefully will satisfy parole. He will satisfy what I intend for him to do all along, which is get treatment. And he will finish out Judge Ferguson's sentence. So I'll grant the motion to mitigate and, amend the River City requirement to be a 60-day River City requirement. Okay?
Thank you, Judge.
Everything else will remain the same.
Thank you.
All right, thank you. Thank you. All right. What do we have next? Thank you for being so patient, Mr. Moore. You've been waiting. All right. Okay, this is a matter of State of Ohio versus Joshua Fisher. Oh, this is Teepin.
Yes, sir.
Mr. Moore was over there. Mr. Teepin has been the one that I want to say thank you. So, case number B2505253. Mr. Craig Teepin is present for Mr. Fisher. Ms. Paige Hennigan is present for the State of Ohio. Mr. Teepin, your client is in Justice Center. Would you like him brought down?
I can move this here, sir.
All right. And we have a jury trial date set January 26th and a final pretrial conference date set January 15th. Do you have discovery?
Your Honor, I was provided some discovery today. I don't know if that's complete discovery at this point, but I was given the reports, and then I also believe there was a photo dump sent to me on Axon.
All right. State, do you want to speak on the discovery?
Sure, Your Honor. We did get medical records. I'm just waiting for that to be copied to him, so that should be provided to him shortly, and then body cam is the only thing past that. So, just waiting on that.
All right. Well, why don't we continue this matter, give, council time to exchange discovery? And, so let's do something, in a couple of weeks, Ms. Howard.
Thursday, December 11th.
That works for me.
Oh, great. Thursday, December 11th at 9:30. And at this time, wait until the trial date of January 26th.
Yes, sir.
Is there anything else you'd like to discuss on behalf of Mr. Fisher, Mr. Cheatham?
Not at this time, Your Honor.
Ms. Nigan, on behalf of the state of Ohio? All right, thank you very much.
Thank you, Judge.
Do you have anything else?
I do, Your Honor. I have, James Ford.
Okay, you want to do that one now? Okay. This is the matter of State of Ohio versus James Torin, case number B2505565. Mr. Torin is present in the courtroom with his attorney, Mr. Craig Teeman, and Ms. Paige Hennigan is present for the State of Ohio. This matter is on today for a bond hearing. We had a pretrial conference date set December 17th. We had a final pretrial conference date set March 12th. And a jury trial date set March 23rd. I know this is just a bond, but hearing, but do you have any discovery?
Your Honor, I was given, some paper discovery today.
Okay, so you're in the process.
That was all I had to say.
Okay, so just in the process of completing discoveries. Okay, so we still have until December 17th for the pretrial. On the court's own initiative, I called for a bond hearing because I looked at this bond and I looked at the allegations and I thought the bond might be a little too low. So I wanted to address it with the parties. Mr. Torin is charged with kidnapping, a felony of the first degree, abduction, a felony of the third degree, having weapons while under disability, a felony of the third degree, receiving stolen property, a felony of the fourth degree, carrying a concealed weapon, a felony of the fourth degree, and domestic violence, misdemeanor of the first degree. And the bond was $16,000 at 10%. I thought that was pretty low for a felony of the first degree, but I don't know any of the circumstances that were made or the magistrate heard to set this bond, but I wanted to address it. So, who would like to start first? Mr. Teagan, Ms. Hennigan?
Judge, I'm happy to start. Your Honor, you're correct about all that, although I will point out a couple things. There were 2 additional charges at Renee that were actually ignored. He did post bonds on that, so he actually posted more than $16,000 at 10%. There was a $10,000 bond on an aggravated menacing that was ignored, as well as a $1,000 bond on using weapons while intoxicated that was ignored.
So he got that bond money back?
I don't believe he has yet. His mom is here. She did post that. She was a little unsure about the return process, but she hasn't actually received it yet. But then, Your Honor, those charges you mentioned at the beginning were added by the grand jury. I will point out it seems to be the same allegations, just a different way charged. This is an alleged altercation with someone who he had a relationship with. They did not live together. They did not have kids together. He has been staying away. He stays with his mom now, who has been in court, or is in court and has been in good contact with me. Certainly, Your Honor, I understand the concern of seeing those high-level charges, but as noted, nothing I've seen in discovery so far or anything I'm aware of alleges any additional conduct. It was just my assumption is that grand jury saw it and decided to be charged in a different way. They dismissed some or ignored some of the charges and added other charges. But Your Honor, I think most importantly, Mr. Torin has been in very good contact with me. He made this court date. He's been very good about staying in contact with me. I had initially called him and told him his December court date. When the court got back to me requesting this court date, he was able to make it happen right away, even knowing what the setting was for. Your Honor, he is in college right now. He works at, or goes to college at Cincinnati State. He's been there for about a year and a half studying horticulture. He does stay with his mom since being released from there. He does not stay with the prosecuting witness. He has had no contact with the prosecuting witness. She has actually reached out to his mom a couple times. On my advice, she has not spoken to her or had any contact with her, but she did show me missed calls from the prosecuting witness to her. I asked the prosecutor if she was able to comply with Marcy's law, have contact with the prosecuting witness, but they requested this. So she indicated she attempted, reached out, but did not get any response from the prosecuting witness. Also, just a brief review of the discovery. I did note that apparently on the 911 call, there were threats from the prosecuting witness to stab Mr. Torin. So, Your Honor, I think what it really comes down to is this charge. Bond was originally set on an altercation between him and the prosecuting witness. That's still the same allegation. It's charged a little differently. Some charges were ignored, some were added. He actually did post more than what his current bond shows. Like I said, I'm not sure the status of that yet, but my assumption is if she hasn't got it back yet, she would, but she can certainly apply that to the bond. But Your Honor, I'd like to be able to see him stay in school. He's already been locked up once for this. He did pay money bond. He's making all the school dates. I believe he will continue to do so, and there won't be any issues with contact or anything along those lines. So with that, Mr. Provence states.
Thank you, Steve.
Yes, Your Honor. The allegations here include that there was a verbal altercation. After that, he had tackled the victim to the ground and punched her. While she was attempting to leave with her son, he pulled out a firearm, pointed it towards the victim, and threatened her, allowing her to leave the apartment. He eventually ended up fleeing the apartment. Officers found him with that weapon on his person. So with all of that, Your Honor, the state does believe that there's a little bond at this time. I will note that I was not able to send subpoenas due to the amount of days. However, I tried calling multiple times. It's a generic voicemail, and I have not received a call back yet.
All right, thank you.
Judge, I think I asked from what the state said. It sounds like Mr. Torin was the one who left the situation. He was gone from the location of the altercation when he was arrested. So, if that kind of what it is.
Well, I'm definitely thinking about Mr. Torin's presumption of innocence in the charges, because that's what we're required to do, is presume innocent unless he's found guilty. But the allegations certainly are very concerning. And looking at his record, he's been in prison 3 or 4 times for some of the similar charges. And so when I have to comply with the law in determining the bond on risk of flight, danger to the community, and public safety, what rings clear of those factors is not risk of flight. He lives with his mom. He's going to school. But what rings clear to me is public safety and danger to the community. So I think the bond's too low. So it looks like on these charges, he only posted $1,600. So I am going to actually increase the bond. And the bond that was posted on the other case that was ignored was 10,000?
A little 11,000, but there's one charge that was $10,000.
Yeah. Now, this bond was set, that was in October, and the bond in my case was set October as well. Well, lucky for Mr. Torrance, since the bond was set, I haven't had any, indications that he has violated the terms, but the bond amount is just too low. I'm sorry, it just is. I'm gonna, increase it to 5,000 anyway. I mean, 50,000 anyway. 50,000 anyway is the bond. So, Mr. Torrance is gonna have to be seated until that bond is posted, 50,000 anyway. Next date will be December 17th. All right, thank you.
We've got another pattern that's on that.
Your Honor, well, the previous bonds, we applied to that.
Mhm.
Thank you. So, 16 months.
All right, this is, ma'am, this is, Ms. Brinson. This is the matter of State of Ohio versus Rosemary Brinson, case numbers B 250374. Ms. Brinson is present in the courtroom with her attorney, Mr. James Moore. Mr. Katie Schumann is present on behalf of the State of Ohio. This matter is set for sentencing today. Ms. Brinson, having entered a guilty plea to count 1, possession of cocaine, a felony of the 5th degree, on October 27th, 2025. And the court, I'm sorry, she did a no contest plea. That's right, she did a no contest plea as charged. There was a finding of guilt. The pre-sentence investigation was waived. There is no victim impact. We're here for sentencing. It was my understanding we continued this because Ms. Brinson is serving a 180-day sentence for conviction in municipal court. Is that right?
Yes, Judge. Wait just one moment, Ms. Brinson. Let me know if you have a question.
Okay.
Judge, I apologize for the proceed.
All right. What would you like to say on behalf of Ms. Brinson?
Yes, Judge. So, I've spoken to Ms. Brinson, and just let the court know about the continuance. We did speak to Judge Mallory, and if the court is inclined to sentence the defendant to River City, Judge Mallory indicated that he would refer to the court on that issue, so he would do a motion to mitigate once they file a sentencing entry reflecting that.
So she's requesting we go to River City?
Judge, I spoke to her just a moment ago, and she's asking for a crossroads.
Crossroads. Is it inpatient?
It's in
Locked
facility?
facility?
It is not a locked facility.
Yeah, no. I'm happy to do River City though. That fine? Okay, do you want treatment then?
What case I didn't, sorry. When you let me talk, I'll explain. When you let me talk, I'll explain.
Okay, well, you can talk now.
I'm pleading to something that I did not do.
Well, you pled no contest.
Yes, ma'am.
And based on the fact that I heard, I found you guilty.
Yes, ma'am.
So I don't want to really talk about doing it or not doing it, but I wanted to really hear your thoughts about treatment. Do you want treatment? I understand. Well, ma'am, can I ask you this? Have you had issues, difficulties with drug abuse before?
Yes, ma'am, I have, but I have more issues with local police than drug abuse. I have my own company, and they just, I won't tell them no dope boys, so they did something that would make me go to jail.
I see. So, you're serving a sentence in municipal court
For stealing.
for stealing.
But they took my machines and put them in, they impounded my lawnmowers and all my lawn care stuff on the bogus charge. And that's where all of this started. And I'm supposed to be getting back surgery, finishing my back surgery and everything. And they just want me to tell them I'm dope boys. And I don't care about what they want. Go do your job, that's fine.
When are you supposed to have back surgery?
I was supposed to, I left the hospital to come to court. And then they put me in jail.
I see. You went to the hospital for your tests or pre-admission?
No, I got some steroids put in my spine.
Oh, I see.
And they're supposed to go all the way up to my neck. And I've been in jail ever since, so I haven't gotten anything else done. And the jail does not want to do anything about my muscles locking up. They won't give me anything but ibuprofen, and that doesn't even help with inflammation tonight.
Yeah.
It doesn't do anything. I'm supposed to get breathing treatments, because I have COPD. Only thing they'll give me is this inhaler. Half the time they don't have the medicine that I'm supposed to be given on the card, that they can give me. They don't give it to me. So I'm just racking up a bill. That's all I'm doing is racking up a bill in jail again. So I will go to River City. I want to be done with this. I just want to be done with all of this so I can get back to my life. I got a 21-year-old daughter who's just starting her life. I just got back connected with. This is not good. It's not good for me at all.
See.
Let's see what
Okay. So she has 180 days serving municipal court. She's not supposed to be released until February.
And I'm supposed to have 90 days. He said 180 days or 90 days and 16, 17 Red Road. And they wouldn't let me go because it was hard.
Yeah. All right. So what I'm going to do, the court has considered overriding purposes of felony sentencing pursuant to revised code 2929.11, the charge to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state and local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Ms. Brinson, I hereby sentence you to a term of 1 year community control with the special condition of completing a 60-day River City program. 60 days. They have a bid available now. Costs and fines remit. Anything else, council?
No, Judge.
Steve?
Nothing else.
So in essence, what I did was, you go to River City tomorrow, you start getting your treatment. And that'll be 60 days from now, so that's 1 month less than ending your term on the municipal court case. So if Judge Mallory decides that he would mitigate your sentence to run, with this sentence, then in essence, you're getting 30 days less, but you're also getting some treatment. All right, anything else?
No, Judge.
You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford the process of the appeal, an attorney will be appointed to help you with no cost to you. You understand? I wish you well. Yeah. All right, who do you have next?
Antonio Williams, Your Honor.
Okay. Ooh, Williams has a whole page.
Well, soon to be shorter, I think.
Okay. So these are the matters of State of Ohio versus Antonio Williams, case numbers P 240-2148, B 250-5817, B 2303-174, and B 230-1127. Ms. Kelly Leggett is present on behalf of Mr. Williams and Ms. Paige Hennigan for the State of Ohio. Ms. Leggett, these matters are on today for a pretrial in the 2024 case, a disposition scheduling conference of the 2025 case, and probation violations on the 2023 cases. Let me start with the newer case, the case scheduling. Do we have dates? All right, when's the next pretrial?
Your Honor, if I may.
Oh, go ahead.
I'm sorry to interrupt. So I found out on Monday that 25, that new case, the federal courts have invited him on that case. So ours will eventually be dismissed. I was hoping that I would have the nominees ready to go today with the day off. It has to go through some approval before I can actually file those. I just was not able to get that here for you today, but those cases are willing to go away. He's indicted federally on it.
So that's the B25 case?
Correct.
What about the B24 case?
Your Honor, that's staying in the state court.
That stays here, okay. So the B25 case, I'm gonna set that for, when did you set the pretrial?
November 20th.
Okay, so we're gonna keep that for November 20th to see what day we do that.
It's a Thursday.
At 9:30 to see if that gets nollied and then go away. We'll obviously put the probation violations on that day as well. And then if he already has a final pretrial conference in the 2024 case, that trial date is December 8th. Are we moving toward trial?
Judge, I would like to speak to his federal public defender about what's gonna happen with his federal case before we do anything with the state case.
Okay. So you'll have done that by November 20th?
I highly doubt that I'm gonna be able to do that with the 20th, since he'll likely be held in the Hamilton County Justice Center that whole time, but I'll work on it.
Wait. You can't talk to his federal public defender until,
I'm not sure if he's gonna get assigned one, if they're gonna come see him. I will stay up to date on it and get in touch with them as soon as possible.
well, I know that the feds don't hold people in our county jail anymore, so he's likely to be moved to the, Butler County, I believe. So you might want to talk to them about that.
Yes.
I'd like to know something on November 20th.
I
Okay?
will give you all the information I can.
All right, so we'll move everything to November 20th. Because the 2024 case is getting close to the end of time. So, yeah. Either we resolve that or, and then the probation violations will just carry on. So hopefully you can talk to the, federal public defender by November 20th. I will tell you that he already has one. That's how the feds work. Like, once the case gets indicted, he has it. You just have to call him to the office and find out who it is. So, all right, we'll continue everything until the 20th of November. Time wait?
Yes.
Okay, thank you very much.
Thank you.
And who are we waiting on now?
I think we're waiting on the prosecutor, Judge.
Okay, so you're ready. Okay. So we won't do a case that will order on that one, just a quick trial. All right, this is the matter of State of Ohio versus Sandra Benz.
That's right.
Case number B2504-238. Ms. Benz is present in the courtroom today with her attorney, Mr. Benjamin Rands, and Ms. Paige Hennigan for the State of Ohio. This matter is set today for a bench trial. It is, that is set at 10 o'clock. It is now 11:26 a.m. How are we going to proceed today?
Your Honor, defense is maintaining our guilty plea.
All right, is defense ready for trial?
Yes.
All right, State?
Your Honor, the state is unable to proceed today. The prosecuting witness is not present. Espino was sent out for 11:12. Additional officers here, we have been trying to contact all morning. I've also contacted last week. The phone number that I have is unable to leave a voicemail. I've not received a call back. Officer today tried to call the barbecue place that this occurred at to see if they could get in contact with the person that this happened to. We have not received a call back. That was about an hour ago that we did that. So the
Who's
state-
the alleged victim?
Your Honor, she was working at the restaurant that the defendant had walked into this street.
So it's
Employee
individual.
there, correct.
I see.
Employee there, certainly this occurred. So Your Honor, the state is unable to proceed without the prosecuting witness who asked for a continuance.
All right, so the state duly sent out subpoenas.
Correct.
The officers have tried to contact the victim.
Correct.
And there's been no response. I see. All right. Mr. Rams?
Considering all that, Your Honor, I move for dismissal.
All
There
right,
were big subpoena returns that I saw on this meeting.
we could have done this at 10 o'clock, 10:01, actually. I'm sorry, because I've been watching the officers sit here for all this time. I was thinking, why are these officers here all this time? Did not know about this. So in the future, if the case is set at 10 o'clock, and given these circumstances, you can call a little earlier if you want to.
Of course, Your Honor, I will say that they were trying to get a hold for it this
Oh.
meantime, so I think that.
They were also trying
Yes,
to
they
get
were
a hold.
trying this morning as well, so
Okay.
I think it's okay, but I will leave them in next time.
Yeah, no, thank you. Okay, I didn't know they were trying to even escalate the fence this morning. So I appreciate it. I just don't like to see officers sitting around because I know you're busy. We need you out there, not in here. I'm going to dismiss this case for warrant prosecution. Thank you very much, everybody. Thank you, officers. Where's Mr. Gunn? Is he here now?
He was here twice and I respect him. He said, we have discovery, and you can say you have two trials.
Is he okay for that day? Okay.
So he said he was.
12:11. Who did that? Who did it? 9:30.
Yes.
Okay, so, Ms. Hennigan, Mr. Diamond had been here twice, but he had other rooms. Ms. Howard is gonna communicate these with him, he said he has a discovery. And that we just set it for another date on December 11th. His client's in lockup. And he waived her presence.
See, when has she been there before? Well, something so. Shouldn't be wrong things.
Yeah.
I don't think she's been there.
So this is her first,
Oh, it's the first trial.
Okay, so I'll let him waive her presence. So we'll continue to December 11th for Ms. Wilson, okay? And then, is that it?
That is it. That's it.
We did it. Great job, Ms. Hennigan, great job. So there's a lot to do today. You did a great job. Thank you. Thank you so much. Huh? Yes. Ms.
Your Honor, I just want to let you know that some of those, I figured out my system with your Friday PSCs, that's which has been a little different for me, but I figured out how to like do my request earlier and stuff like that. I figured out a system, so I'm sorry.
Good.
For some of those, I'm sorry, but I am trying to.
No, that's it.
Yes.
It does take a minute
Yeah.
to get your system down, so, no, that's no problem at all. Thank you. You're doing a good job. All right, we are done. And Ms. Howard could post down the, live stream. We are done for today. Or are we done for today? Or we have something at 1:30? It's at, I think it's at 1:45.
Is it 1:45?
Yes. You have something at 1:45. And we have time, just so we want to get time to. Easy peasy. Thank you.
Got that joy going on. That's awesome.
Yeah, you know,
I haven't seen his presence.
it is, it is.
He's so good.
There was a code up here, we're trying to figure out who's it is. So
Let me see it. Is that, did Mr. Benjamin have?
That's what I don't know if it's.
I'll text him, just leave it there, I'll text him.
Because he had a coat on.
Yeah, that's his.
It might be his.
So is it okay to leave it then?
Yeah, we'll text him and have him, thank you for doing that.
Thank you.
We'll, text him and have him, come down here.
Thank you.